Welcome to Unpublished Opinions, an Institute for Justice Roundtable podcast. The podcast where Institute for Justice attorneys get together and give their unvarnished and unpublished opinions about the law. I'm your host, John Wrench, the Assistant Director of the Center for Judicial Engagement at the Institute for Justice. We're recording on a very lucky Friday the 13th of December, and today I'm joined by two of my distinguished opinionizers and beloved colleagues, senior attorneys Anya Bidell and Sam Gedge. Anya and
Nothing
Sam,
distinguished about anything around here.
Welcome to Unpublished. Of course you're distinguished. Welcome to Unpublished Opinions.
What's up?
No, you're great, John. You're the great one here. You're distinguished.
You're the distinguished assistant director.
We're just going to compliment each other for the next hour or so. And I'm actually going to continue complimenting you because it's fitting that both of you are such extremely talented writers, if I may say so, because we're going to start with a controversial bit of writing technique, if you can call it that. And so, Sam, if he who puns would pick a pocket, what about he who explains their puns in excruciating detail?
Oh,
Yes, John, you know my views. I think I sent them to in all caps a few days ago. I didn't realize this was the first thing we were talking about. But yeah, so I'm not a fan, to answer your question directly, John. I think we should all pause, take a moment to think twice if you're ever going to have a pun in a brief or a law review article. Probably just decide not to do it. But if you are going to do it, really pause and think about whether you're going to drop a lengthy footnote explaining your pun in excruciating detail. I don't know that there's ever a time when that's really the right rhetorical move.
If you're not confident in your puns, don't put them in there. If you are, don't explain them.
Right.
Precisely.
So it sounds like the position is puns are potentially problematic, but certainly problematic if you explain them.
Yeah, and by the way, the two that Sam sent around,
Which I was trying to find. I don't know if any of you have them in front of you.
So one was in the wake of something, right?
Yeah.
And the judge started explaining what wake actually means. And the other one was...
It means multiple things, which is why it's very funny.
And the other one was the title of the paper, which was License to Kill, right? And then they were explaining license to kill versus license to kill.
So I feel like we're losing a little bit in translation, and I've pulled them up. Can we just kind of indulge our listener with the actual? Okay, so this is the U.S. Naval Academy Affirmative Action case from last week out of the District of Maryland. Very controversial case, and I got through the first sentence of this 179-page opinion before I honestly stopped, because here's how it starts. Plaintiffs, students for fair admission, brought this action on October 5th, 2023 against the U.S. Naval Academy in the wake of its successful litigation in Students for Fair Admission versus Harvard. And then they drop a footnote on wake, as Anya mentioned, and footnote 1 says, as those familiar with the U.S. Navy well know, a wake is a trail of water, often choppy, that appears behind a moving boat. And then don't take their word for it. Merriam-Webster's definition of wake from the 2020 edition. It also refers to the aftermath of something that has passed id. And I just honestly stopped reading right there. I'm sure it may very well be an excellent opinion, but it also reminded me, as Anya says, of this law review article from a few years ago, License to Kill. And to be clear, I don't blame the authors of License to Kill, because I think it might be a student note, and it definitely had the vibe of whoever was editing the piece forced them to drop a half-page footnote.
Yes, that's how I read it too.
So someone's probably to blame, but I don't think it's necessarily the authors there.
Yeah, it's interesting because it seems like part of the problem is humor when you're using it is kind of it's like a recognition game a little bit, where it's like inside jokes reveal who's in the know. A reference to literature or film, it tests other people's familiarity with those things. And it's rewarding when the joke isn't lost and you're kind of forcing it to not be lost. And you're also just not, like Anya said, you're not confident enough that people will get the joke. And so you have to say, I just made a joke. Isn't very funny.
It reminds me actually of this practice of people when they text or write emails and they say something and then they put a smiley face on. or like some other emoji. And it's like, if you don't think that the people who are reading this email will get that you were being sarcastic, for example, then maybe that's not the right audience to be saying this thing to.
Though I honestly would have preferred just like a smiley face emoji in the District of Maryland in place of that footnote. Like a wink maybe. Because honestly, like, was it even a pun? Like people say in the wake all the time.
No, it's not a pun. I don't think it is.
Yeah. I think it's just the use of a word, the correct use of a word.
Yeah. License to Cal is at least, a little closer. And even then, license to Cal is kind of funny. You don't need to include the footnote.
You don't need to explain it. Everybody gets it.
Yeah, it's not.
I agree with Sam. I bet it's the editor who is like, people, we're not, we can't just be saying things like that without explaining them. So why don't you drop a footnote?
Yeah, every proposition needs a footnote. And so what they're doing, they're like, what are they doing? They cite a 1990s Central District of California decision that itself describes the character trait of the license to kill from James Bond. It's truly a fascinating footnote. Neither here nor there. But it did grind my gears.
We should put it in the episode notes.
Yeah, I should say on the merits, they take a very dim view of IJ's views on occupational speech. The entire premise of the license to kill PUM is that of course the government should be able to punish you for talking about vegetables, providing advice about vegetables without getting a license. But very good punsters. It has
nothing to do with us criticizing them.
Yeah, and not only wrong but not funny.
Well, but very funny, and they didn't need to explain it. They should have just had the courage of their pun related conviction.
Courage of your pun.
Yeah.
Do you think that this like tendency of maybe over casual writing has been influenced a bit by, I don't know, I think it's fair to say that there's kind of a movement on the Supreme Court of at least a couple of justices that really favor informal writing. Do you think that has kind of trickled down into saying it's actually very cool to write informally and that this kind of humor has, increased because of that? Or do you think they're unrelated?
I don't. The informality of the Supreme Court writing doesn't even come close to what some of these writers are trying out. Just because Kagan uses contractions doesn't mean that she is all of a sudden going to be doing all this other stuff that these writers are trying on. I don't know. I mean, that same goes to, for example, Paul Clement being very informal in his oral arguments, right? But it doesn't seem to cross the line, and I do think that it's been going on for a while compared to this, which is a more recent trend, more influenced by the TikTok generation, I think.
TikTok law review, as I understand it, is very, very hopping. Though I do think like the phenomenon of kind of punny and kind of attention-grabbing law review article titles is nothing new, right? Like It's always like something eye-catchy, like the history of dog catcher law, in 18th century Russia or whatever. So that is nothing new, I think.
Yes. I'm trying to think of examples, but I can't think of any right now, but it's true.
Yeah, I guess
forever.
The example that I'm thinking of is I do remember a Justice Gorsuch opinion, and I don't know if it was when he was on the circuit court or when I think he was actually already at the Supreme Court. And the opening paragraph had a lot of alliteration that was very deliberate.
Yeah, that was a Supreme Court opinion.
Yeah, and I thought, I don't know if I like this or not.
I think he's backing away from this a little.
I think so too. It's a little bit less Gorsuch style, or maybe he's developing Gorsuch style. In regard to other questionable practices, Anya, I know you have some thoughts about recess appointments. Can you tell our listeners a bit about what recess appointments are and why people are talking about them right now?
Yeah, that's. I don't understand why we're talking about them right now. I guess that's why I'm proposing this as a topic, so we can talk about it right now and never ever talk about it again. Although I don't think that's going to happen. This whole discussion about whether if Trump's nominees, become very controversial and he doesn't feel like he can get enough senators to vote for them, that he can get them through the practice of recess appointments. And there is a very interesting decision, National Labor Relations Board, where the Supreme Court struck down Obama's attempt to nominate somebody during not really a recess appointment, not really during recess, but during like a 3-day breaks between pro forma sittings. Really, I mean, Republicans were really being intransigent at that time. They didn't want to let him put nominees in, so they wouldn't go into recess. And they, even during this 1-month break, they would still show up twice a week, do the gravel thing and go home. So he tried to nominate this National Labor Relations Board people in these 3-day periods where they wouldn't actually be sitting. And the question before the Supreme Court was whether that's a recess appointment where the Constitution actually allows you to nominate somebody. And the Supreme Court, the liberal justices struck down Obama's nominations. They said that no, these 3-day periods are not really recess and you can't do that. But if it's like 10 days, that's a bona fide recess and you should be able to do that. In response to that, Justice Scalia wrote a very powerful, I suppose, concurrence, because it fundamentally agrees that those 3 appointees were appointed improperly and illegally, but he writes a concurrence with the other 3 justices on the conservative side signing on to it, right? Roberts, Thomas, and Alito, where he basically says, first of all, the whole recess appointment thing is anachronism, right? Back in the olden days when the Constitution was written, I understand why that was necessary. But second of all, even if you just look at the text of the statute, you shouldn't, that text of the statute does not get you to where Justice Breyer's majority opinion got to. And one of the more interesting parts of that is when he says that the vacancy has to arise during recess, right? It has to naturally happen when senators are away. So all this that we're talking about today, these vacancies are not naturally arising during recess. So we have 4 very conservative justices on the record in not such a distant past saying that no, when we're talking about recess, the vacancies have to naturally occur during that recess. And I heavily doubt that Gorsuch, Kavanaugh, and ACB are gonna be disagreeing with that reasoning. And let's just listen to 2 clips by Justice Scalia where he really kind of nails down those 2 points.
Like many of the constitutional rules that define the structure of our government, the advice and consent rule is inefficient. Governing would be much simpler if the president could choose the people he wanted to fill certain offices without having to get a bunch of senators to agree. But the point of the Constitution is not simply to make government run efficiently. It is also to restrain government, even when that results in less efficiency, and by doing so to protect individual liberty.
And second quote.
The majority ignores the reality that it is very difficult for Congress or the Senate as a body to counter presidential excesses. Presidents can act quickly and unilaterally, and they are nearly always motivated to expand the powers of their office. But collective action problems and procedural inertia make it much harder for Congress and the Senate to act. And its members often are not motivated to resist encroachment by a president who is the leader of their own party. The majority's deference to executive practice in this case will therefore resonate well beyond the dispute here at hand. Sad but true.
And maybe we can talk about how, Sam, maybe you can comment on how the Scalia's broader point about the practice of recess doesn't even make sense anymore, and it is like inconsistent with separation of powers.
No, honestly, like I'll be candid. I feel like we're in a safe space here. I have no views about recess appointments, but I think maybe that's to your point, Anya, that they're just an anachronism. So I have a really hard time caring.
You should care about basically the executive branch rolling over the legislative branch, right? I mean, that's the whole point. Like, you have a separation of powers, and there is something, and Scalia talks about it. Like, yes, presidents should get their picks for the most part. But Congress can't just roll over and play dead. It is pretty interesting how Scalia pretty much anticipates what is happening today. He's talking about how, in situations where you have the president's party controlling the Senate, that they will actually be more than happy to roll over and play dead. And he says, but sorry, guys, you have a constitutional duty, and you have to perform that constitutional duty.
Yeah, I mean, I think there's an interesting analogy that you could make to some of the concerns with Chevron, which I know isn't directly related, but there's this concern about Congress kind of abdicating its authority to the executive, and the whole concern with this contrived recess is that, one of the problems is that the Senate can kind of avoid, if they want those appointments, they can kind of avoid any consequences for letting them happen, instead of actually voting, to confirm them or not. And so I don't know. It is an interesting issue, and there's an interesting law review article that we can post with the show notes that is about this topic. That's quite good.
Let's do it.
Any puns in the title?
Any puns? No, we wouldn't post it if it had puns in the title.
It might just have very subtle puns, and we're just not in the know enough.
Yes,
reflects poorly on us.
But which is fine. No need to explain it to us. Thank you very much. I do love your point about Chevron, though. That's exactly right. Like, there's certain things that you need to be exercising your responsibility, otherwise it essentially atrophies.
Right.
Yeah, I mean, I do wonder how much accountability senators think that they have for, confirming people who are not qualified, right? Like, it just strikes me that most of them are probably how many voters are going to care about this? But that's not to detract from your broader point, Anya, obviously.
Yeah, I mean, speaking of circumventing standard procedures, we chatted a bit about sua sponte decision-making in a previous episode, but we are super interested in sua sponte decision-making. That's when courts decide to address an issue that hasn't been raised by the parties in a lawsuit. And Sam, do you have any thoughts about courts of appeals engaging in sua sponte decision-making, when it's okay or not?
I should, since I proposed this topic for the agenda, but I haven't given it a moment's thought. I guess I'll say a couple of things, though. First, the Second Circuit, at least some judges on the Second Circuit, have this charming habit of sometimes referring to nostra sponte decision-making when they're talking about we ourselves engaging in sua sponte decision-making. So that's fun. But I mean, so it's actually difficult, I think, because my initial kind of gut reaction is to say, it's bad. And I think that gut reaction is probably right. I stand by it. You don't want the judges just kind of going out on a truffle hunt and kind of thinking about arguments that the parties didn't raise and that potentially didn't have a chance to respond to, right? That degrades the adversarial process and makes people feel like they haven't been heard. It can implicate due process concerns if people haven't had a meaningful opportunity to respond. There's all sorts of bad things about sua sponte decision-making. There's one law review article that the catchy part of the title refers to playing God, and then : something sua sponte decision-making. But it does seem like there have to be some circumstances when maybe a degree of sua sponte action is appropriate. Obviously, subject matter jurisdiction, we don't need to. That's the low-hanging fruit. But you can imagine situations where all the litigants just aren't very good lawyers, and everyone's kind of litigating some case based on just a fundamental misreading of a statute, or they don't recognize that there is a controlling circuit case on point that resolves the issue, or they don't realize that there's a statute that resolves the issue. And in that circumstance, right, it can't be that, well, the panel has to just proceed from the parties' shared mistaken premises and just kind of like go off on this frolic and detour and kind of close their eyes to the fact that there's a binding precedent, or close their eyes to the fact that, yeah, the parties are talking about statute X, but actually statute Y is the right one. So in those circumstances, right, like it seems like, okay, I guess some kind of sua sponte decision making is okay. You would still want them, just as a matter of procedure, I think, to give the parties a heads up. Ideally not by like sandbagging them argument, but like sending out an order saying, file a supplemental brief on this. But it seems like there's like a role for courts to kind of take that initiating step sometimes. And I just don't really know where exactly the line is. I don't know if you guys have any thoughts.
Yeah, it's... I like that the courts have that flexibility, but again, it should very much be an exception, not a rule. And maybe that's the way to think about the line. Like, generally speaking, this kind of a thing should be disfavored. However, in certain circumstances where, justice requires that, then there is this flexibility that courts have. And I totally agree that if a court wants to do that, then they should order supplemental briefing. They should also announce that this was raised sua sponte inside their opinions, right? Some of the problems arise from the fact that they just proceed as if it was normally briefed, and for people who then go back and read those opinions, they don't even know that this kind of an issue arose sua sponte, so there's not even an accountability there. And maybe also courts sometimes should consider alternatives, like certifying the question to a state appellate court or something like that, where, there is some sort of a process to it rather than them just making it out of whole cloth. But again, I think that having that flexibility is important. I know that some state courts frown upon that much more than federal courts. So that's interesting too. For example, in Pennsylvania, sua sponte stuff is very heavily disfavored.
Oh, that's interesting.
Yeah, that's kind of... just because federal judiciary does that doesn't mean that all state courts do that. Again, though, sometimes you need this kind of stuff, but there needs to be process.
Yeah, that seems right. Sorry, you go ahead, John. I had another thought on this, but
no.
I want to hear your thought. No. John Wrench is the host.
Oh, stop. You're my guest.
He's the distinguished one here.
Yeah,
let's go.
Assistant director.
We're going to change the name to sua sponte. Yeah, I mean, I feel like I share Sam's framing of it, is that it's probably bad for all of the reasons that we've talked about. But I also could imagine being a judge and there being legal issues, and my ultimate obligation is to get the law right. And there's going to be situations where the parties have not gotten the law right. And I guess sometimes what you see is the courts making a judgment call where the parties haven't really made the best arguments. And if you're not going to address the issue sua sponte, you at least have to make clear what you're not addressing, and just say, the parties didn't raise this issue, hint, hint, for the next litigant, they probably should have. We're not addressing that here. Like, at the very least, you should make that clear if you're not going to address it sua sponte. But I mean, I do think that a lot of damage has been caused when courts address certain things sua sponte. Like, I just was thinking about this recently because I'm working on a law review article that implicates the line of Fourth Amendment cases holding that drug dog sniffs are not a search under the Fourth Amendment. And incredibly, the case that introduced that idea was not about searches at all. United States versus Place. It was about a seizure. And so the lower court didn't address whether there was a search. The parties didn't argue that there wasn't a search. It was just totally irrelevant. And the court decides to address the issue itself, and it kind of invents it out of whole cloth. And then that becomes doctrine. And it all kind of got there without the aid of adversarial analysis. It's awful. It's awful. Yeah. It's like discovering that something is built on, a house built on sand, but it's very frustrating because it fundamentally altered the law, and it's hard to claw it back once it's there. Well, Speaking of justices telling us about the recesses of their minds, many Supreme Court justices donate their private papers to institutions of their choice, like the Library of Congress or academic institutions, after they leave the bench or die, which are often the same event. And those papers typically include things like notes on conferences, memoranda, exchange between the justices about cases, draft opinions, correspondences, and things like that. And in other words, it's kind of a treasure trove of information about the court's decision-making process that are normally obscured from the public. So, Anya, I wondered if you had any thoughts about whether those papers are relevant to how people should think about litigating cases, especially the cases that are discussed in those papers.
Yes, but only as background information. Those kind of papers are incredible, and law students and professors and lawyers should devour them. And especially if you're litigating a case and a judge is discussing that case in his paper, in his judicial papers, that's something that is so good to know, including just trying to kind of like understand what were the forces that were driving this. But I would not explicitly cite to them or use them in an oral argument or anything like that. But I would use them as like a secret power to become a better advocate for my side.
Sam, do you have any thoughts about this?
No. I largely agree with Anya. I looked at the files on Younger versus Harris, Younger abstention case. I dug that out from the Library of Congress. Well, I think I sent them an email and paid them a lot of money, and then they emailed me electronic versions. And I know that some of our colleagues have looked at these as well. I find them interesting. Like the ones that I've happened to look at are kind of disappointingly less interesting than I was hoping. Like there weren't like super in-depth memos that like really blew my mind. But that might just be that the cases I picked are really boring cases about abstention. But yeah, like I agree with Anya. Like I would feel pretty weird citing that stuff. Like it feels like though like legislative history, except kind of even more fraught. You guys probably remember that. I think was it in the Dobbs argument that Chief Justice Roberts alluded to Justice Blackmun's papers in argument, and I don't remember what the context was, but even he was kind of like sheepish about it. Like, oh, I know I shouldn't be talking about this, or there's a dispute about whether any of this matters, but you know, Harry Blackmun said this in his notes or whatever.
Because he was investigating the abortion issue for himself, wasn't he? And so he was kind of like keeping a diary where he was analyzing pros and cons. But that's pretty much like legislative decision making.
Right.
And that also reminds me of my oral argument prep for Gonzalez. I did a lot of stuff like going back and listening to the oral arguments related on all of the related questions, including basically like, okay, Chief Justice Roberts, let's listen specifically to what he asked in this case, and in that case. And given the trajectory of his thought in these three previous cases, what is it that he is most likely going to be concerned with in this case, right? And I did it for every justice. And I think you kind of can overthink what they're actually thinking. And I definitely got that when I was up there answering Chief Justice's questions. And it was like, I thought I lived in his head forever. I thought I knew exactly what it is that he was concerned with. And I think he truly is concerned with things like split-second decision-making and the difficulty of untangling, probable cause from the actual motive. But that's not what he was thinking about in my case, right? Just because he was thinking about it in those other cases, and just because those other cases are extremely related to my case, doesn't mean that that's what he's thinking in my case. Justices are looking at every case as it comes to them. They decide so many other cases. They think about so many other cases. And it's really like, you can't just tell Chief Justice, actually, when you, in this other argument, when a very similar answer was given, you were much more receptive to that. So So it's like human thinking too is like evolving. What you're writing in your diary today doesn't really necessarily mean that this is going to be the case a week from now. So it's really good for background, but you really don't want to overemphasize it, I don't think.
Yeah, and to kind of carry on the legislative history comparison, like I'm thinking of like the notes that some justices have kept from conference or memoranda that they're sending around. But even those notes or those memoranda don't necessarily even reflect what the justice is thinking. It might be reflecting how they're trying to influence other justices. It might be, an issue that they were stuck on in that case, but then got over in the future. I mean, it's hard to tell what those papers are useful for outside of the fact that you are certainly getting to know, one way or another, you're getting to know the justice better, which is a pretty cool thing that you have access to. Yeah. Do you think that if the papers are used more and more, because I think they are getting accessible. I mean, some of the last several justices have donated their papers to different institutions, and they're not all online, so that's a little bit of an obstacle to accessing them. But I do wonder whether if the papers are used more and more, it could actually create a risk that future justices will make their papers private. They won't actually make them public.
Or maybe a concern that like they'll start like just papering the record, right?
Censoring themselves, yes.
Yeah, or like, like they didn't get their way in the majority opinion, so they write a memo saying, well, I understand this to mean the opposite, and 50 years down the road. I mean, that would be a major long game, but yeah.
Hey, Madison played that long game. James Madison played that long game, right? He kept editing his papers from the Constitutional Convention until the day he died. So
legislative history comparison continues. Yeah.
Anya was talking about Supreme Court arguments and bringing this back to younger abstention, if I may. I was reading some old younger abstention-related Supreme Court transcripts a few weeks ago, and I can't go into the details because I think it would make this podcast like R-rated. But if you look at the transcript from Huffman versus Pursue from like 1974, like the government's lawyer, they're just like made some real rhetorical choices. And if any of our listeners are still listening like 40 minutes in, like they seem like the kind of people who might get a kick out of it. So go check out Huffman versus Pursue and start controlling F some of the most colorful language you can imagine, and you'll get a little treat.
Wow.
Well, thank you for changing the rating of the podcast. We'll include that. We'll make sure to include that, or not at all. So besides reading their private papers, another way for the public to engage with the Supreme Court is to attend oral arguments in person. Although oral arguments are open to the public, if you've been before, you've probably found that there is limited seating. And so that's especially dependent on whether there's like a high profile case or a high school field trip. A lot of things can get thrown your way on the day you go to stand in line. So you're not really guaranteed a seat. But that may be about to change, at least for those with some luck. The Supreme Court announced yesterday, on December 12th, that it'll be implementing a pilot program where the public can apply for a seat to watch an oral argument through an automated online lottery program. And the program will kick off in February of 2025. The lottery opens shortly after the monthly argument calendar is set, and then the deadline to enter will be 4 weeks before the particular argument. So I was wondering if either of you had thoughts about whether you think that pilot program will be a good thing for public access to the court or a bad thing.
I like it, and especially because it is a pilot program, so they can always, walk it back. I am worried that some people would abuse it, where you are just like trying, to get as many lottery seats as possible, and then not even coming to the argument, right? And they're kind of making it clear, hey, if you actually get the seat, but you are not coming, let us know so we can award it to somebody else.
There's no penalty for not coming. So I agree. I think that's going to be hard, because normally if you get there and you see that the line only has 20 people in it, if you stand in the line, there's going to be a pretty good chance that you get in. But now that you have this program, you don't really know how many seats have been reserved and then how many of those people aren't going to show up. So you probably do have to wait until until you're in or you're not.
Just to talk up the idea of going to kind of the non-exciting Supreme Court arguments, I went to one which I thought was exciting a few years ago involving F-bar penalties, and the courtroom was almost empty. But it was the argument where you had like 3 protesters stand up and start like shouting stuff and getting arrested. So it ended up being exciting. A blast for everybody, really under the radar.
That's exciting. Based on how they treat people who are falling asleep, I imagine they were not particularly gentle with the protesters.
Yeah. It happened in the first minute or so. But yeah, Dan Geiser was the advocate and really kind of showed a lot of aplomb, was not thrown off by that. But yeah, really good time.
What were the protesters protesting? It was several years ago, you said.
Yeah, it was either abortion or like in a very out-of-date fashion, Citizens United, even though it was like 12 to 13 years after the fact. Yeah.
I think it might have been Citizens United, actually.
I think it was.
Thinking back to the media coverage of it. I wonder if they were also like sophisticated protesters who kind of understood that this argument is unlikely to be very crowded, so it would be easier for them to stage the protest?
I don't know.
I think one of the interesting things about the pilot program is you don't make reservations for the day, so it's argument specific.
Yeah.
And so I'm interested to see how that's going to work out too, because I almost always have stayed for both arguments, even if I'm not super interested in the other one. So that's kind of interesting that you have to apply separately.
I wonder if a marshal is going to walk up to you and say, "You saw only reserved for oral argument number 1. Please vacate the premises."
Yeah, we punched your ticket for your first argument. You need to get off the train. So before we wrap up, I wanted to know if there were any books, shows, movies, or any other forms of entertainment you're consuming that it would edify our listeners to know about. Sam, do you have anything that entertains you?
I was hoping you would pick Anya first, because I just realized I can't remember. We started watching Skeleton Crew, the Star Wars kids show. It's delightful. I'm probably still reading the same Master and Commander book I was the last time you asked me. Plus a biography of Francesco Crispi, the famous late 19th century Italian prime minister. John, as you doubtless know.
How famous?
At the time, he was one of the best known European statesmen.
Wow.
But he ended up resigning in disgrace after the Battle of Adwa in 1896, which is probably why it sounds like you haven't heard of him, John.
Yeah.
Speaks very poorly of your level of culture.
It does.
But I think that's what I got
Sorry,
going
I
on.
asked.
Anya?
So I am reading, speaking of biographies, Angela Merkel's biography, which is fascinating. First of all, because she's my mother's age and she was growing up in East Germany. And it was my mother was growing up in Ukraine at that time, and there's quite a bit of overlap, and my mother and I didn't really talk too much about her upbringing, so it kind of brings me closer to her in that sense. But another thing that's really, really fascinating is Merkel said that she wanted to be like a social scientist or maybe a politician. She wanted to do something much more with people, but she ended up becoming a chemist, right? She ended up with hard sciences. And she said the reason she ended up with hard sciences is because at least in hard sciences, you could still say that 2 + 2 was 4 and that the law of gravity still existed. And that just resonated to me so much. It's true that even in like authoritarian states, it is very difficult to deny science, because if you deny science, you're kind of shooting yourself in the foot as well. So it's this one space where you actually have the freedom of mind, even though there's still like a limited exposure. And she talks about it too, right? She's like, I thought I was the best scientist in the world, but when the war fell and we compared our research, we were significantly behind. But there's still at least room to be yourself and not have to censor yourself. So I find that fascinating. And along those same lines, what I'm watching right now is this French soap opera, essentially called A French Village. And it's about the German occupation, first Vichy regime and then the German occupation of France during World War II. And it is fascinating to watch it, especially when you see rebels going, and taking out Assad and taking control of Syria, because you kind of see the parallels and how across cultures, across timelines, there is same old thing of like power struggle, right? And when you have one group of people coming to power and then other people having to like figure out their way around it, whether they cooperate or whether they resist, and then other people coming to power, and all of a sudden those resistors, they are in power now, and how are they going to behave? Are they going to be are they essentially going to be as bad as the other guys were, or are they going to do something different? And how people act very differently depending on whether they are sort of in power or whether they are out of power, and how often human nature basically means that not like people are the same, it's just they act differently depending on circumstances. So those are two things that I'm reading, watching, that really remind me of like what's going on today. It's really fun to draw those parallels.
Super interesting. I'm not really watching anything new. I'm watching the new Dune show.
I want to do that. It's on my list.
Yeah, I'm enjoying it. I mean, it's I'm very cautious of spin-off shows. I would say on principle, I'm kind of anti-spin-off show because I feel like it often kills or degrades the original thing. I'm a little bit into Better Call Saul. I think I'm in the second season somewhere. I took a break from it. I think Better Call Saul is as good, if not better, than Breaking Bad. So I think that breaks the rule, I think. And I think that this Dune show is good. It's just, I really liked the Dune book. I've only read the first two Dune books, but I really liked the book. I thought both movies were good, but I liked the second one more. The show is solid. I think it's worth watching if you like the Dune universe. But the thing that I probably most enjoyed recently was I test played a Supreme Court themed board game, First Monday in October, which is made by Fort Circle Games. And the goal is to gain as many points as possible by winning cases or placing clerks on judges and then attempting to elevate those judges to the court. And then you win cases depending on whether you're able to influence the judicial philosophy on congressional power, executive power, free speech, and I think civil rights is the fourth category. And those are always changing throughout the game depending on the justices on the court and the things that the players are doing. It was a ton of fun. And normally I think when I see a niche game like that, I think that it's probably someone's passion project, but it's probably not very good as a board game. And I don't think this fits in that category whatsoever. It was very good. It was well made. It was fun. And for anybody who's like a law nerd, I think that it would be a great game. But I think it comes out next year sometime. So if you're interested, it's called First Monday in October by Fort Circle Games. So that was a ton of fun to play. And
First Monday in October. Ooh.
Yeah, highly recommend it. It's basically made for people like us. So at least anybody who's into board games and likes law. Yeah. Well, thank you, Anya and Sam, for coming on. I hope that our listeners enjoyed the show and tune into our next episode for a new rotation of equally esteemed guests and clever opinions. Until then, that's just like your unpublished opinion, man.
I'm gonna do like a Chinaman, go and get some hops.